The grand, towering arches of the Royal Courts of Justice in London have stood for centuries as a silent witness to some of the most profound, dramatic, and transformative human conflicts in modern history. Behind those heavy, imposing oak doors, the fates of empires, massive corporations, and the most celebrated figures in society are weighed with meticulous, clinical precision. For decades, the public has looked upon this institution not merely as a venue for resolving technical disputes, but as an ultimate theatre where truth, power, and reputation collide in the most public manner imaginable. In our contemporary media-saturated world, where every whisper is amplified and every private moment is vulnerable to global scrutiny, the battle for the narrative has become the ultimate high-stakes gamble. When individuals of immense wealth, global prestige, and historical legacy decide to step into this arena, they are not simply asking for a legal ruling. They are risking everything they have built upon the unpredictable wheel of justice. The intersection of royal bloodlines and the modern media landscape has always been fraught with an undeniable, simmering tension, a delicate dance between the necessity of public visibility and the desperate human desire for personal privacy. For years, this tension has brewed beneath the surface of British society, characterized by an ongoing quiet warfare played out across front pages, broadcast studios, and legal chambers. It is a world where a single word can alter the course of a lifetime, where notebooks from decades past hold the power to vindicate or destroy, and where the line between a legitimate journalistic inquiry and an unlawful invasion of a person's private life becomes the central battleground of an era. To truly understand the magnitude of the events that have recently transpired within these walls, one must first appreciate the atmospheric weight of a conflict that has been decades in the making, a conflict driven by deep emotional scars, immense financial investments, and an absolute, unyielding refusal by either side to blink first in the face of total reputational ruin. As the morning mist clears over the River Thames, the legal machinery of the United Kingdom grinds forward, bringing together an extraordinary cast of characters who seem more suited to a high-wrought historical drama than the sober reality of a modern courtroom. On one side stands a figure born into the absolute pinnacle of global privilege, a prince whose entire existence has been documented, analyzed, and occasionally torn apart by the relentless gaze of the public eye. Driven by a profound sense of personal mission, a desire to avenge past grievances, and an absolute conviction in the righteousness of his cause, this individual has mounted an unprecedented crusade against the very institutions that have recorded his life. Facing him is not a single opponent, but a collective titan of modern media, an assembly of powerful news organizations and veteran journalists who view their work not as an infringement, but as a fundamental pillar of a free society and a robust public discourse. The legal briefs generated by this confrontation are staggering in their complexity and their sheer volume, filling thousands of pages with detailed allegations, forensic analysis of past methodologies, and fiercely contested testimonies. For months, the anticipation surrounding this confrontation has built to a fever pitch, with legal experts and casual observers alike wondering how a conflict of such magnitude could ever find a clean resolution. The sums of money involved are almost incomprehensible to the average citizen, with combined legal fees escalating into tens of millions of pounds, turning the courtroom into an incredibly expensive battlefield where every hour of argument costs more than many people earn in a year. Yet, beneath the staggering financial metrics and the dazzling star power of those involved, the core of the issue remains intensely human, revolving around fundamental questions of trust, betrayal, the boundaries of acceptable behavior, and the heavy price that society extracts from those who live their lives in the spotlight. To comprehend the intricate dance that takes place within these legal proceedings, it is essential to explore the unique mechanisms of the British legal system. particularly the profound differences between the rules that govern criminal wrongdoing and those that dictate the outcomes of civil disputes. In a criminal courtroom, the stakes are measured in human liberty, requiring a standard of proof so high that a jury must be entirely certain, beyond any reasonable doubt, before rendering a verdict of guilt. The civil arena, however, operates on an entirely different philosophical and practical framework, one that is often explained through the vivid metaphor of a classic set of weighing scales. In these chambers, the burden of proving a case rests entirely upon the claimant, the individual who has stepped forward to demand justice and restitution for a perceived wrong. To achieve victory in a civil matter, one does not need to achieve absolute certainty or banish every shadow of doubt. Instead, the objective is simply to tip those metaphorical scales ever so slightly in one's favor, achieving what the law defines as the balance of probabilities. If a claimant can demonstrate that their version of events is merely 51% accurate, that it is more likely true than not, the law deems them victorious, granting them the full weight of a judicial endorsement. This seemingly lower threshold theoretically provides a significant advantage to those seeking redress, making the civil courts an attractive avenue for high-profile figures looking to validate their grievances against powerful adversaries. Before we delve deeper into how these intricate legal mechanisms ultimately manifested in one of the most astonishing, devastating, and comprehensive judgments ever delivered by a British court, I would like to invite you to take a brief moment to support our ongoing coverage of these monumental stories by subscribing to the channel, ensuring you never miss a single detail of these unfolding historical dramas. The historical backdrop of this confrontation is deeply rooted in a turbulent past an era from 20 years ago when the methods of the popular press were thrown into a harsh, uncompromising spotlight, leading to public outcries, intense investigations, and even criminal convictions for those who crossed the line into unlawful information gathering. For the individuals who felt the direct impact of those intrusive practices during their youth, the emotional wounds have never fully healed, creating a powerful, enduring motivation to seek an absolute, definitive reckoning. This long-standing animosity has transformed what might have otherwise been a straightforward legal dispute into an incredibly intense, emotionally charged crusade, where the objective is not merely financial compensation, but a sweeping moral victory that would echo through the halls of history. The legal teams assembled to fight this war represent the absolute pinnacle of the legal profession, featuring brilliant minds, veteran solicitors, and high-powered advocates who have spent decades navigating the most treacherous waters of the High Court. These attorneys are accustomed to dealing with immense egos, limitless wealth, and clients who often believe that their status places them above the ordinary constraints of legal strategy. As these two massive forces prepared to collide in a final decisive trial, the atmosphere within the legal community was charged with an undeniable sense of history in the making, as everyone understood that the impending judgment would either deliver a historic victory for a royal crusader or hand a monumental, sweeping vindication to the giants of the British press, leaving absolutely no middle ground and ensuring that the fallout would be nothing short of catastrophic for the losing side. The long-awaited climax of this legal warfare finally arrived when Mr. Justice Nicol handed down his monumental, deeply analytical 436-page judgment, a document that legal experts and media observers will undoubtedly dissect for generations to come. To describe the outcome as a mere defeat for the claimants would be a profound understatement. It was a total, absolute, and comprehensive annihilation of their legal arguments across every single count and across every single individual involved in the action. The High Court did not merely reject the assertions put forward by the prince and his high-profile co-claimants. It dismantled the very philosophical and evidential foundation upon which their entire crusade had been meticulously constructed over several years. In a series of extraordinarily scathing and precise observations, the judge called out the fundamental flaw of the claimants' strategy, explicitly stating that they had approached the court with an impermissible methodology, essentially asking the judiciary to assume that, because certain information was private, it must have been stolen through unlawful means. This striking rebuke struck at the heart of the team's legal logic, exposing a fatal reliance on past history rather than present reality, as the court firmly established that a history of institutional misconduct cannot serve as a legal substitute for specific, contemporary, and verifiable proof. The atmosphere within the courtroom as these words were delivered was heavy with a palpable, stunned silence. As the sheer magnitude of the press's vindication began to crystallize, transforming what had been promoted as a historic day of accountability into an unprecedented, catastrophic rout for the royal claimant and his wealthy allies. To fully understand how a legal venture of this magnitude, backed by tens of millions of pounds and guided by some of the most celebrated advocates in London, could collapse so spectacularly, one must examine the specific evidentiary disasters that unfolded during the course of the trial. Central to the claimant's case was an absolute reliance on what they termed propensity, a legal argument suggesting that because certain news organizations and specific journalists had engaged in phone hacking and illegal information gathering 2 decades ago, it was entirely logical to infer they had done so in these specific 94 articles. The defense met this argument with an unyielding traditional insistence on the strict rules of evidence, a position that the judge ultimately vindicated in the strongest possible terms by pointing out that a journalist's behavior in the past does not dictate the behavior of another journalist today, nor does it mean the same journalist would act unlawfully years later. This legal reality turned the courtroom into a harsh arena where vague suspicions and emotional convictions were systematically ground down by a clinical demand for hard empirical facts. The gap between what the claimants believed had happened to them and what they could actually prove to a legal standard became an unbridgeable chasm, leaving their high-powered legal team, led by David Sherborne, exposed to a devastating judicial counterattack that left no stone unturned and no reputation unexamined. The desperation of the claimant's case was perhaps most vividly illustrated by the extraordinary, almost surreal collapse of their key witness, a private investigator named Gavin Burrows, whose involvement in the proceedings read like a twisted thriller. Burrows had initially stepped forward to provide a massive 21-page witness statement filled with lurid, sensational allegations of placing listening devices in cars, bugging cafes, tapping thousands of phones, and utilizing hidden microphones to spy on the private lives of the elite on behalf of the newspaper group. This document had been the crucial catalyst that persuaded prominent figures, including high-profile individuals and long-time campaigners, to join the prince's legal action, believing they finally possessed the silver bullet that would bring down their media tormentors. However, just months before the trial was scheduled to commence, Burrows completely upended the litigations by issuing a secondary statement that entirely retracted his previous assertions, claiming the original document was a total fabrication and that his signature had been brazenly forged. When he finally appeared via a video link to testify, the scene was nothing short of bizarre, with the witness sitting in a distant office in the Philippines wearing casual attire, openly laughing and mocking the claimant's attorneys, which forced the judge to repeatedly intervene to stop the farcical display. The spectacular deflation of this critical pillar of evidence left the claimant's legal strategy in absolute ruins, raising profound questions about the vetting processes, the credibility of the material being brought before the High Court, and the wisdom of proceeding when the central foundation of the case had openly turned to dust. As the evidentiary framework continued to unravel, the courtroom witnessed intense, deeply personal confrontations that pushed the psychological tension of the trial to its absolute limit, particularly during the cross-examinations of seasoned journalists like Katie Nicholl and Charlotte Griffiths. The claimant's legal team attempted to mount aggressive, character-destroying attacks against these reporters, suggesting that their elaborate social lives and professional interactions with the prince's social circle were merely sophisticated stories designed to provide plausible deniability for systematic, illegal phone hacking conducted from their homes. The journalists defended their professional integrity with fierce, articulate conviction, presenting detailed notebooks and calendar entries dating back 20 years, demonstrating an impeccable standard of record-keeping that left an indelible impression of professionalism upon the court. The defense advocates aggressively challenged the claimant's assertions, at one point accusing the prince's team of relying on fantasy and projecting an alternate reality that had no basis in traditional investigative journalism. These highly charged exchanges highlighted a deeper cultural clash between a royal figure who viewed any media interest as an inherently malicious invasion of privacy, and a press corps that maintained its right to cultivate sources, attend social gatherings, and report on public figures through entirely legitimate legal means, a distinction that the final judgment upheld with uncompromising clarity. The financial ramifications of this comprehensive legal catastrophe are equally staggering, escalating into sums of money that would threaten the stability of almost any ordinary individual and creating an immense, complex battle over the ultimate distribution of costs. The combined legal fees for the proceedings have climbed toward an astronomical £50 million, a reflection of the massive teams of solicitors, barristers, researchers, and forensic experts employed by both sides over years of intensive preparation. During the preliminary budget hearings, the court had already expressed severe dissatisfaction with these numbers, with the judge labeling the projected expenditure as manifestly excessive and entirely disproportionate to the actual damages being sought. The traditional rule of British civil litigation dictates that the losing party must shoulder the financial burden of the victor's costs, meaning the claimants are now facing a terrifying financial reality where they must not only pay their own multi-million-pound bills, but also contribute massive sums to indemnify the newspaper group. Although there are capping mechanisms and standard assessments designed to limit the recovery of costs to reasonable parameters, the newspaper's legal team is already preparing to argue for an indemnity basis of assessment, asserting that the litigation was inherently vexatious, pursued in bad faith, and built upon tainted evidence, a move that could expose the prince and his co-claimants to the maximum possible financial penalty, leaving them to find millions of pounds down the back of the sofa to satisfy a judicial debt that represents a complete and unmitigated disaster. The long-term consequences of this legal catastrophe extend far beyond the immediate financial wreckage, slicing deep into the delicate fabric of personal and professional reputations that have taken lifetimes to construct. In the immediate aftermath of the judgment, prominent media figures delivered incredibly biting assessments of the royal claimant's motivations, describing his public crusade as the deeply misguided manifestation of a profoundly angry and isolated individual. Critics pointed out the immense irony of a public figure embarking on an absolute war for personal privacy while simultaneously publishing highly revealing personal memoirs and participating in global broadcast projects that detailed the most intimate dynamics of his own family life. This apparent double standard severely undermined his moral authority in the eyes of the public and the court, casting his legal battle not as a noble defense of fundamental human rights, but as a deeply personalized, emotional vendetta against an industry he has grown to detest. For a prince who has defined a significant portion of his adult identity through this conflict, the total rejection of his claims by a senior high court judge represents an immeasurable psychological blow, leaving him completely exposed to the harsh reality that his deeply held personal convictions were simply not supported by the strict, unyielding laws of the land to truly understand why this disaster occurred. One must analyze the complex psychology of elite celebrity litigants and the unique pressures they exert on the high-powered legal teams that surround them. In the rarefied world of immense wealth and global prestige, individuals are rarely accustomed to hearing the word no, often surrounding themselves with advisors who reinforce their absolute certainty and validate their personal grievances. This insular environment can easily breed a profound sense of entitlement, leading high-profile figures to believe that the ordinary rules of evidence, strategy, and risk simply do not apply to them, or that a deep pocket can effectively bully a powerful adversary into a quiet settlement. Veteran legal experts have noted that when massive egos, limitless capital, and intense media scrutiny converge in a single room, a dangerous form of confirmation bias often takes hold, blinding both clients and their attorneys to the fatal weaknesses within their own case. Rather than presenting a single, tightly focused and completely rock-solid claim, the legal team chose to launch a sweeping, multifaceted assault that attempted to overwhelm the defense with a massive volume of allegations. This shotgun approach ultimately proved to be their undoing, as the inclusion of weak, unverified, and speculative claims served to taint the credible elements of their case, creating a fatal vulnerability that the defense systematically exploited until the entire litigation unraveled. The broader implications of this ruling for the future of the British press and the landscape of investigative journalism are nothing short of profound, marking a definitive turning point in an era that has been defined by intense hostility between public figures and the media. For decades, major news organizations have faced an onslaught of litigation stemming from the historical misconduct of the industry, resulting in over 1,000 settled claims and hundreds of millions of pounds paid out to high-profile victims. This continuous financial and reputational bleeding had created an atmosphere of cautious vulnerability within newsrooms, leading many to believe that the press would always fold when faced with a sufficiently aggressive and wealthy claimant. By refusing to sign up to an off-ramp agreement that included a no-crowing clause, and by insisting on defending its journalists through a full public trial, the newspaper group has established a powerful new precedent that will undoubtedly reshape legal strategies across the kingdom. The total vindication of the reporters and the explicit praise delivered by the judge regarding the quality of their long-term record-keeping sends a clear, unmistakable message to the legal community that the era of automatic settlements is officially over, and that any future claimant must possess ironclad empirical evidence before daring to drag a major media institution before the High Court. The reputational damage resulting from this comprehensive defeat has also sparked intense speculation regarding the prince's future standing within global society, raising serious questions about whether he will now become an increasingly toxic figure for corporate partners, charitable organizations, and elite circles. While this remains an entirely civil matter involving no criminal charges or threats to personal liberty, the public demonstration of such a profound error in judgment and a complete lack of evidentiary foundation leaves a lasting stain on his credibility. The comparison to other members of the royal family who have faced severe public disgrace is inevitable, as society has shown an increasing willingness to completely cast out those whose actions threaten the standing of the institution or demonstrate a severe disconnect from reality. Without a massive corporate backer or an incredibly wealthy ally willing to absorb the astronomical financial penalties, the prince faces a highly uncertain path forward. One where his capacity to influence public discourse and mount future campaigns will be severely restricted by the lingering shadow of this judicial disaster. The tragedy of the situation lies in the fact that his actions were so clearly driven by a genuine, deeply rooted trauma relating to the historic mistreatment of his family. Yet his inability to separate those valid emotional scars from the clinical requirements of the law led him into a trap of his own making. As the legal community turns its attention toward the final costs hearings scheduled for the end of July, the true financial fallout will be calculated with mathematical precision, forcing a complex reckoning between the claimants and the specialized insurance companies that provided their initial backing. While many observers assumed that high-profile individuals would be entirely uncovered in a high-stakes action of this nature, the reality of modern litigation reveals a highly commercialized system where litigants frequently secure substantial insurance policies designed to indemnify them against potential losses. In this specific action, individual policies covering millions of pounds were utilized to mitigate the immense financial risks, a strategy that originally appeared highly viable given the industry's historical track record of settling such disputes out of court. However, insurance companies are notoriously meticulous when it comes to examining the fine print of their policies, and they will undoubtedly mount a fierce resistance against paying out these massive sums if they can demonstrate that the nature of the evidence changed dramatically or that critical information regarding the credibility of key witnesses was withheld. This impending legal skirmish guarantees that the drama surrounding this case will continue to simmer for many months, ensuring that the primary actors remain trapped in a relentless cycle of litigation that offers absolutely no clean exits and no easy path toward personal or professional redemption. Ultimately, the grand narrative of this historic confrontation serves as a stark, cautionary tale about the absolute limits of power, wealth, and emotional conviction when measured against the cold, impartial machinery of a modern constitutional democracy. The High Court has reaffirmed its traditional role as an unyielding arbiter of truth, an institution that remains entirely indifferent to the titles, the prestige, or the global fame of those who step before its bench, demanding a single currency that cannot be forged or purchased: specific, verifiable, and contemporary proof. For the veteran defense solicitors who managed this extraordinary victory, the case represents the absolute pinnacle of a career spent navigating the most complex, high-stakes environments imaginable, proving that an unyielding adherence to the fundamental principles of evidence will always triumph over the most sophisticated public relations campaigns and the most deeply felt personal crusades. As the dust begins to settle over the royal courts of justice and the media landscape adjusts to this profound shift in power, the characters involved are left to contemplate the heavy lessons of a war that has altered the trajectory of their lives, leaving behind a monumental judicial precedent that will stand for decades as a definitive testament to the day the press stood its ground and a prince lost his ultimate gamble.